Good day. I am Prince Jan Molina, and I am going to report the 2016 revised implementing rules and regulations of Public Act number 9184, otherwise known as the Government Procurement Reform Act, section 50 to 56. Section 50, Direct Contracting. Direct contracting or single source procurement is a method of procurement of goods that does not require elaborate bidding documents. The supplier is simply asked to submit a price quotation or a pro forma invoice together with the conditions of sale. The offer may be accepted immediately or after some negotiations. Direct contracting may be resorted to by concerned procuring entities under any of the following conditions. First is procurement of goods of proprietary nature which can be obtained only from the proprietary source. Example, when patents, trade secrets, and copyrights prohibit others from manufacturing the same item. Next one is when the procurement of critical components from a specific supplier is a condition precedent to hold a contractor to guarantee its project performance in accordance with the provisions of its contract, or those sold by an exclusive dealer or manufacturer which does not have sub-dealers selling at lower prices, and for which no suitable substitute can be obtained at more advantageous terms to the GOP. Section 51, Repeat Order. Repeat order when provided for method of procurement of goods from the previous winning bidder, whenever there is a need to replenish goods procured under a contract previously awarded through competitive bidding. Repeat orders shall likewise be subject to the following conditions. First is unit prices of the repeat order must be the same as or lower than those in the original contract. Second is the repeat order will not result in splitting of contracts, requisitions, or purchase orders as provided for in section 54.1 of this IRR. Third is except in cases duly approved by the GPPB, the repeat order shall be availed of only within six months from the date of the notice to proceed arising from the original contract. Fourth is the repeat order shall not exceed 25% of the quantity of each item in the original contract. In order not to exceed the 25%, the goods under the original contract must be: first is quantifiable, divisible, and consisting of at least 4 units per item. Section 52.1. Shopping is a method of procurement of goods whereby the procuring entity simply requests for the submissions of price quotations for readily available off-the-shelf goods or ordinary or regular equipment to be procured directly from suppliers of known qualifications. This method of procurement shall be employed in any of the following cases. First is when there is an unforeseen contingency requiring immediate purchase. Second is procurement of the ordinary or regular office supplies and equipment not available in the procurement service involving an amount not exceeding the thresholds prescribed in the Annex H of this IRR. Section 53, Negotiated Procurement. Negotiated procurement is a method of procurement of goods, infrastructure projects, and consulting services, whereby the procuring entity directly negotiates a contract with a technically, legally, and financially capable supplier, contractor, or consultant in any of the following cases. First is the two-field biddings. Second is the emergency cases. And the third one is takeover of contracts and adjacent or contiguous. Next is the agency to agency. Next one is the scientific, scholarly, or artistic work, exclusive technology, and media services. Next is the highly technical consultants. Next one is the defense cooperation agreement or the defense inventory-based items. Next is list of real property and venue. And next one is the NGO participation. And last, second to the last is the community participation. And the last one is the United Nations agencies, international organizations, or international financing institutions. So let us now elaborate the following cases stated in the previous slide. First is the two-field biddings. The two-field biddings, there has been failure of competitive bidding or limited source bidding for the second time as provided in the section 35 of the Act and this IRR. Next is the emergency cases. In case of imminent danger to life or property during a state of calamity, or when time is of the essence arising from natural or man-made calamities, or the causes where immediate action is necessary to prevent damage to or loss of life or property, or to restore vital public services, infrastructure, facilities, and other public utilities. Next is the takeover of contracts. Takeover of over contracts is rescinded or terminated for causes provided for in the contract and existing laws where immediate action is necessary to prevent damage to or loss of life or property, or to restore vital public services, infrastructure, facilities, and other public utilities. Next is the agency to agency. Procurement of goods, infrastructure projects, and consulting service from another agency of the GOP, such as the DBM-PS, which is tasked with the centralized procurement of common use supplies for the GOP in accordance with letters of instruction number 755 and EO 359 series 1989. Next is the scientific, scholarly, or artistic work, exclusive technology, and media services, where goods, infrastructure projects, and consulting services can be contracted to a particular supplier, contractor, or consultant, and as determined by the hope for any of the following. First is the requirement. The requirement is for work of art, commissioned work of services of an artist, a specific artist skill, example, singer, poet, writer, painter, and sculptor. Next is the scientific, academic, scholarly work, or research, or legal services. Next is the highly specialized life-saving medical equipment as certified by the Department of Health, or DOH. Next is the scientific, technical, economic, business, trade, or legal journal, magazine, paper, subscription, or other exclusive statistical publications in reference, or media documentation, advertisement, or announcement through television, radio, newspaper, internet, and other communication media. Next is the construction or installation of an infrastructure facility where the material, equipment, or technology under a proprietary right can only be obtained from the same contractor. So, let us now tackle the highly technical consultants. Highly technical consultants, in the case of individual consultants hired to do work that is 1. Highly technical or proprietary, or number two, primarily confidential or policy determining, where trust and confidence are the primary consideration for the hiring of the consultant. Next is the Defense Cooperation Agreement. The DND may directly negotiate with an agency or instrumentality of another country with which the Philippines has entered into the Defense Cooperation Agreement or otherwise maintains diplomatic relations when the procurement involves major defense equipment or material and or defense-related consultancy services. Next one is the defense inventory-based items. The DND may directly negotiate with a supplier or manufacturer in procuring inventory-based items, which pertain to major defense equipment or material as contemplated in section 53.8. So next one is the small value procurement. Procurement of goods, infrastructure, projects and consulting services where the amount involved does not exceed the threshold prescribed in Annex H of this IRR. Next one is the lease of real property and venue. List of real property and venue for official use subject to Annex H of this IRR. Next is the NGO participation. When an appropriation law or ordinance earmarks an amount to be specifically contracted out to non-governmental organizations or NGOs, the procuring entity may enter a memorandum of agreement with an NGO subject to the guidelines 22 issued by the GPPB for the purpose. Next is the community participation, where in the interest of project sustainability or to achieve certain specific social objectives, it is desirable in selected projects or its components to call for participation of local communities in the delivery of goods, including non-consulting services and simple infrastructure projects, subject to the Community Participation Procurement Manual or CPPM issued by the GPPB. Next is the United Nations agencies, international organizations, or international financing institutions. Procurement from specialized agencies of the United Nations, international organizations, or international financing institutions. Next is the Section 54, or terms and conditions for the use of alternative methods. First is the splitting of government contracts is not allowed. Next is the procuring entity may dispense with the advertisement in the newspaper and posting requirement as prescribed in Section 21.2.1 of this IRR. Next is the BAC through the Secretariat shall post for information purposes the notice of award, contract or purchase order, including notice to proceed if necessary in the PhilGIP's website, the website of the procuring entity concerned if available, and at any conspicuous place reserved for this purpose in the premises of the procuring entity, except for contracts with ABC of 50,000 pesos and below. Next is the except for limited source bidding under Section 49 of this IRR. Submission of bid securities may be dispensed with. Performance and warranty securities. Performance and or warranty securities are required for the following alternative methods of procurement in accordance with Sections 39 and 62 of this IRR. Alternative methods of procurement. First is limited source bidding. There is performance security. Warranty security is required for highly specialized types of goods. Next is the direct contracting. There is no performance security. And warranty security is required. Repeat order. There is no performance security. And for warranty security, there is warranty security for the repeat order. And to failed biddings, there is performance security. And for the warranty security, in no case shall warranty security be required to the procurement of consulting services. Emergency cases. Procuring entity may require performance security depending on the nature of the procurement project. However, for infrastructure project, performance security is required. Procuring entity may require warranty security depending on the nature of the procurement project. In no case shall warranty security be required in the procurement of consulting services. Takeover of contracts. There is performance security and there is warranty security. Adjacent contiguous. There is performance security, and for infrastructure projects, warranty security is required. Small value procurement. Procuring entity may require performance security depending on the nature of the procurement project. However, for infrastructure projects, performance security is required. Procuring entity may require warranty security depending on the nature of the procurement project. In no case shall warranty security be required in the procurement of consulting services. Manufacturers, suppliers, distributors, constructors, and or consultants are mandated to register with PhilGIPs and provide a PhilGIPs registration number. Next is the specific terms, conditions, and documentary requirements, including the limitations and restrictions for the application of each of the alternative methods mentioned in this article shall be provided for in Annex H of this IRR, and guidelines specifically issued for this purpose. So now let's proceed to the Rule 17, Protest Mechanism. Section 55, Protests on Decisions of the BAC. Decisions of the BAC at any stage of the procurement process may be questioned by filing a request for consideration within the 3 calendar days upon receipt of written notice or upon verbal notification. The protest must be filed within 7 calendar days from receipt by the party concerned of the resolution of BAC denying its request for reconsideration. A protest shall be made by filing a verified position paper with the hope concerned, accompanied by the payment of a non-refundable protest fee which shall be paid in cash in accordance with the following schedule. ABC range 50 million and below, and the protest fee is 0.75% of the ABC. Next is the more than 50 million to 100 million, and the fee is 500,000 pesos. Next is the more than 100 million to 500 million pesos. Fee is 0.5% of the ABC. For more than 500 million to 1 billion, the protest fee is 2,500,000 pesos. For more than 1 billion to 2 billion, the fee is 0.25% of the ABC. For more than 2 billion to 5 billion, the fee is 5 million pesos. And for more than 5 billion, the fee is 0.1% of the ABC. The verified position paper shall contain the following information: the name of bidder, the office address of the bidder, the name of project or contract, the implementing office or agency or procuring entity, a brief statement of facts, the issue to be resolved, and such other matters and information pertinent and relevant to the proper resolution of the protest. In addition, the bidder shall likewise certify under oath that he has not theretofore commenced any action or filed any claim involving the same issues in any court, tribunal, or quasi-judicial agency, and to the best of his knowledge, no such other action or claim is pending therein. Next is, if there is such other pending action or claim, he is including a complete statement of the present status thereof, and if should thereafter learn that the same or similar action or claim has been filed or is pending, he shall report that fact within 5 days therefrom to the hope wherein his protest is filed. Failure to comply with the foregoing requirements shall not be curable by more amendment of the verified position paper. Next is, let's tackle about the section 56, the last section for my report, resolution of protest. The protest shall be resolved strictly on the basis of records of the BAC. The hope shall resolve the protest within 7 calendar days from receipt thereof, subject to the provisions of the existing laws of the authority, of department secretaries and the heads of agency, branches, concessional commissions, or instrumentalities of the GOP to approve contracts. The decisions of the hope concerned shall be final up to the limit of his contract approving authority. With respect to LGUs, the decision of the local chief executive shall be final. Thank you.